Hello, I'm attorney Russell Kohn of the Kohn Law Office in Oceanside, California, where we help people who've been injured by others obtain full and fair compensation for their injuries and their losses. Now, some of the auto crashes we handle are caused by uninsured drivers. If you have this coverage on your auto policy, then you have rights. You may be wondering if you need to hire an attorney to handle this claim. Well, the insurance company and the insurance adjusters and their attorneys are taught to pay you less and keep more for the company. That's a cold, hard fact. So let's discuss the issues affecting your rights. Recently, we handled an uninsured motorist case where our client had medical opinions that he needed both back and neck surgeries due to injuries from the collision. The insurance company only offered $25,000 initially, eventually raised to $50,000 and then to $100,000 later. We arbitrated the case on behalf of our client and we got an award of $741,000. We are now pursuing a case for bad faith against that insurance company. So let me give you a little legislative update regarding California law. California drivers who purchased uninsured motorist insurance are not receiving the protection that they believe they purchased. The coverage is intended to protect the insured if they're injured by an underinsured driver. Currently, the insurance companies are able to deduct what you receive from the party at fault from your underinsured coverage limits. We don't think most people know that that's what happens. We think they're buying insurance to cover their damages, and they're not going to have that coverage reduced because of what they receive from the other driver. So recently, there was a legislative bill in California sponsored by Senator Bill Dodd as Senate Bill 1107 to address this situation. Unfortunately, at the last minute, those provisions were dropped. And although his bill increased the liability limits from $15,000, $30,000 for injury up to $30,000, $50,000, it dropped provisions having to do with underinsured motorist coverage. So currently, the insurance company are still able to reduce your coverage limit by how much you receive from the party at fault. So you need to adjust your uninsured motorist coverage limit to account for the fact that if the party at fault has low limits, your insurance company is going to get a credit for what you receive from the third party's insurance company. Currently, the statute of limitations to file a claim for uninsured motorist is 2 years. Now, you don't have to file in court. What you have to do is send a demand for arbitration within 2 years of the auto collision. The claim against the party at fault does not have to be filed unless you think that maybe you don't know whether or not they're insured. Because if you don't file against them and you just do an arbitration demand, and later it's found out that the party at fault had insurance, your insurance company could deny the claim on the uninsured motorist coverage because the party at fault had insurance. So you should know in California, usually the statute of limitations is 2 years from the date of collision to file a claim against the party at fault. But if you're sure that the party at fault did not have insurance, the demand for arbitration needs to be sent by certified mail and include a statement under oath about whether the claimant has a workers' compensation claim pending. The attorney can sign that declaration on information and belief for their client. Also, I highly recommend that the demand for arbitration also include a list of arbitrators proposed to be the arbitrator in the case. This will shorten the time to file a petition to compel arbitration if the insurance company doesn't agree on one of the arbitrators that you have proposed.